On behalf of everyone here, I acknowledge the elders, the families and descendants of the Wurundjeri people who have been custodians of these lands for many generations, and I acknowledge the land on which we meet tonight was the place of age-old ceremonies of celebration, of initiation and renewal, and that the local Aboriginal peoples have had and continue to have a unique role in the life of this university. So tonight, I think, is a very special one. We have this tradition at the university for professors to present an inaugural professorial lecture. This is particularly interesting because our inaugural professorial lecturer is Bernadette McSherry, but she's already done one. But that was at another university. So from the University of Melbourne's perspective, it is inaugural. But it's an opportunity for our new professors to give a public lecture and tell the public why the university was so wise in selecting them. I have no doubt about that happening tonight. This lecture is in partnership with the Melbourne Law School, and I'm delighted to have their support. And as you hear from Bernadette's CV, you'll see why that's important, because Bernadette is an internationally recognised legal academic in the fields of criminal law and mental health law. She completed a Bachelor of Arts with honours and a Bachelor of Law with honours here at Melbourne before going on to complete a Master of Law degree in 1990. Her PhD was titled Insanity, Automatism and Criminal Responsibility. This was completed at the Osgoode Hall Law School, York University in Toronto in 1996. She then went on to Monash and did a diploma in psychology. And that was in 2001. So you can see the convergences of different fields. Bernadette is a fellow of both the Australian Academy of Social Sciences here in Australia, but also the Australian Academy of Law. Bernadette has also become an Australian Research Council Federation Fellow. She did that in 2007. That's most prestigious indeed. She is President of the Australian and the New Zealand Association of Psychiatry, Psychology and Law, a legal member of the Victorian Mental Health Tribunal and a member of the Mental Health Law and Policy Institute at Simon Fraser University in Canada. Bernadette has a remarkable achievement in terms of Australian Research Council grants. She's had two Criminal Research Council grants and numerous consultancies, and also authored numerous books and articles on criminal and mental health law. Of course, she supervised doctoral students as well to completion, master's students, honours students, and is currently conducting research on an ARC, Australian Research Council discovery project entitled Regulating the Use of Restraint on Persons with Disabilities, Model Laws and Guidelines. Also this year, Bernadette's been honoured by being presented with the Mental Health Services Award for exceptional contribution to mental health services in Australia. And I congratulate you, Bernadette, on that. I think I have previously, but I do it again in public. So tonight, Bernadette will explore the regulation of teacher responses to challenging student behaviour, and that's something that's of interest to many people in education and indeed law. So now will you please join me in welcoming Bernadette McSherry to the front to give her oration.
All right, let's see whether this works. So as you've heard, I have a legal background, so I'm looking at Breaking Bad tonight from a legal perspective. All right, so that's me, and that's me with Toby, the social equity dog, who is very, very good at promoting positive behaviour amongst his human companions, rounds us up, gets us out of the house every morning to walk. And you'll see here that I tweet. So I do encourage you, as long as you have your phones off and your computers off, to tweet, if you do, under the hashtag Dean's Lecture, because it's always useful for me to read the hashtag to see what people are actually getting out of my lectures. If what I think the message should be is actually getting across. And if you want to, you can always write questions to me via Twitter as well. So please feel free to do that. I thought I'd take the opportunity just to talk a little bit about the Melbourne Social Equity Institute. I'm the director of this particular institute. There are 5 of these, what are sometimes called virtual institutes at the University of Melbourne. And we have some funding from the Deputy Vice-Chancellor Research, and we seed fund interdisciplinary research projects, in our case, to ameliorate disadvantage in some way. And it's a terrific job because I learn a lot about what people are doing in other disciplines, and it really has real-world impact in many ways. One of the projects that I've been involved with as part of the Social Equity Institute was one for the National Mental Health Commission. And they came to us and said, can you do some research on reducing seclusion and restraint in mental health settings? So a lot of what I'm talking about this evening is a result of that particular project. And I pay tribute to the project team, some of whom are here tonight. Good to see them here. And some of the findings from that were that there's perhaps some resistance towards thinking that restrictive interventions can ever be abolished. That sometimes if people are being particularly aggressive, we have to seclude them, we have to restrain them. So that's one of the questions that I'll be asking in this presentation. Are there alternatives? What can we do to reduce restrictive interventions, not only across healthcare settings, but across educational settings as well? All right, so Breaking Bad. Why Breaking Bad? Probably because a lot of people are here thinking I'm going to talk about Walter White. Much as I would love to do this and talk about the ethics of drug dealing when you don't have a national health service, I'm not going to do that. But Breaking Bad, the term, is used in the southwest of the United States. And it's meant to refer to someone who flaunts the rules, who raises hell, and who shows behaviours of concern. So I thought I'd start by talking about, well, how does one define behaviours of concern in particular and restrictive interventions? What are we talking about in this particular presentation? So to start with, there is no common definition. There's no national consensus on what behaviours of concern mean in educational settings. So that's the first point to note. Different bodies have come up with different sorts of definitions. The first one I want to mention is this from the Victorian Department of Education and Training. It refers to a very broad range of behaviours. Self-injuring behaviour, such as hitting, kicking walls, headbanging. Attacking other students or staff, including hitting, biting, kicking, hair pulling. Throwing furniture or objects at students and staff. A verbal threat of harm, which you believe a student will immediately enact, or running onto a road or near some other hazard. So that's a very broad sweep of a definition of behaviours of concern. Other organisations define this differently. And I'm just referring here, there are lots of different definitions out there, but the New South Wales Office of the Senior Practitioner picks up an English definition of what's called challenging behaviour. And this is quite different. So this definition talks about behaviour of such intensity, frequency or duration as to threaten the quality of life and or the physical safety of the individual or others, and is likely to lead to responses that are restrictive, aversive, or result in exclusion. So I think those words, intensity, frequency, or duration, are important here. This seems to narrow the focus somewhat of what would constitute behaviours of concern. In the healthcare setting, disability and mental health legislation generally talks about the risk of harm to self or others. Some states talk about the risk of physical harm, some refer simply to serious harm. So already there are different definitions of what behaviours of concern are. It would be really good to get some consensus. Do we include threats within this? Or are we really talking about some sort of behaviour that's immediately putting another person or the person, him or herself, at risk of harm? Similarly, when we look at restrictive interventions, there is no common definition across Australia. One of the best definitions I've found in my research in relation to mental health actually comes from Tasmania. And Tasmania has a Mental Health Act which defines these different types of restrictive interventions. So it defines physical restraint as bodily force that controls a person's freedom of movement. Mechanical restraint is defined as a device that controls a person's freedom of movement. This can be a wrist strap, it can be a belt, it can be a harness. So it's a device that controls freedom of movement. The Tasmanian Mental Health Act also refers to seclusion. And this is defined, and I'm paraphrasing here, the deliberate confinement of a person alone in a room or area that the person cannot freely exit. So a room or area that the person cannot freely exit. And I think those definitions are clear and concise, but there's a range of other definitions across other jurisdictions. What's also interesting in Tasmania is that it defines chemical restraint. I'm not talking about that tonight, but that's one area that's worthy of examination. And one of my doctoral students, Juan, who I think is here tonight, there he is right at the back, he's actually looking at how do you regulate chemical restraint in healthcare settings. I'm not too sure whether it actually occurs in educational settings. It may, for all we know. Yes, someone's nodding. And so that might be another area that we need to research. So they're the definitions. I want to shift now to the legal framework. This is where, if you think it's complex already in terms of definitions, that we don't really have a national consensus, then it gets even more layered in relation to the law. So let me take you through it. Let's start with international human rights laws. There are a number of United Nations conventions that are relevant here. Human rights are basic rights that we all have. They're inherent simply because we are humans, regardless of our nationality, age, status, and so on. And it's important to note that children have human rights. This was not always the case. Children were not seen as having rights for many years, and in some countries that is still the case. But under international human rights law, and in particular the Convention on the Rights of the Child, which Australia ratified in 1990, children have human rights. They have a right to education. They have a right to liberty and security of the person. They have right to equality before the law. And they have right to freedom from cruel, inhuman or degrading treatment or punishment. Lots of other rights, but I think they're the most important in relation to this particular topic. Now, Australia is a signatory to many of the relevant conventions, civil and political rights, economic and social rights, and so on. There's also recently the Convention on the Rights of Persons with Disabilities, and I'll be talking about children with disabilities in a while. In terms of this international human rights framework, when a country or a state ratifies a convention, it says, I agree to be bound by these obligations. However, this is where it gets a little bit complicated, it does not become part of Australian law unless Parliament passes certain provisions. So we have some human rights that are part of Australian law, but others that are not. However, it's very important to have this framework as a guide to what we do in practice. So let me move now to Australia. Every state and territory has different laws regulating responses to behaviours of concern. There is no national law. And in each state and territory, you have a combination of what's sometimes referred to as common law, case law, and legislation. So it's very murky, I suppose, what the law is in relation to regulating responses to behaviours of concern. I'm going to concentrate on Victoria because I know it the best, but I want to emphasise for those watching this on video, this is not legal advice. This is my interpretation of what the law in Victoria says. As well as international law, there's different laws across Australia. In Victoria, there's a number of different laws. Now, I'll take you through each one because I think it's important that we know what the law permits and where there are particular gaps. So in Victoria, the Education and Training Reform Act is the one that regulates government schools. And it sets out that you can suspend or expel a student if there are behaviours of concern, but it doesn't talk about restrictive interventions. It doesn't talk about bodily contact or mechanical restraint or anything like that. There are regulations, and regulations are a little bit different to legislation. Regulations are about implementing what the statute says. So in the regulations, it makes it clear, Regulation 14 says, corporal punishment is prohibited. That in itself is interesting because I assumed it was prohibited across Australia. But when you look at the Western Australian and Queensland criminal codes, there is still a provision enabling reasonable chastisement of a child. So again, you can see here that what may be the law in one state is very different in another. So the important regulation here, and this is up on a website that I'm about to show you, I hope, is Regulation 15. And this says a member of the staff of a government school may take any reasonable action that is immediately required to restrain a student of the school from acts or behaviour dangerous to the member of staff, the student or any other person. So reasonable action that is immediately required to restrain a student from acts or behaviour dangerous to the others or to the student, him or herself. It's interesting when I was discussing this topic with some teachers in my family that the immediate response was, oh, you can't touch the kids. Well, you've got Regulation 15 saying if it's reasonable, it can be permitted. So that's very interesting to note. In relation to these other areas of law, Under criminal law, any touching without consent is technically an assault. However, there are all these exceptions to that. So we know if we're on public transport, the day-to-day jostling, that's not seen as assault. Putting a hand on someone's shoulder in sympathy is not seen as an assault. And in relation to someone striking out, about to hit someone else, there is the defence of self-defence. And again, similar language comes up. The person must believe that the conduct is necessary in self-defence and the conduct is a reasonable response. So you can see this notion of necessity, of reasonableness coming through in relation to the use, at least, of bodily force. Occupational health and safety law applies to schools, and it places a duty on schools to eliminate or minimise risks to health and safety as so far as is reasonably practicable. So you could argue under that there's actually a duty to step in to stop behaviours of concern. And finally, just mentioning tort law, or the law of negligence, this imposes a duty of care on teachers. And that duty is to take reasonable steps to protect students from risks of injuries that are reasonably foreseeable. Reasonable, reasonable, reasonable. You can see this coming all the way through what the law says. Now, what is reasonable, of course, can only be tested by a court of law. And in the absence of case law, then it's up to teachers within a school to work out what is reasonable. So overall then, under Victorian law, my summary is that physical restraint is permitted if it's a necessary and reasonable response to an immediate risk of harm. That's certainly the tenor of all these laws that are relevant here. In relation to seclusion and mechanical restraint, however, there's a real gap. There's nothing directly on this. There's no regulation directly on can seclusion be used, can mechanical restraint be used. What we do have, though, is a policy from the Department of Education and Training, and I'm going to see if I can take you to this site because I think it's important that you know that this exists. All right. Okay, so there we go. So, School Policy and Advisory Guide, Restraint of Student. So you've got your purpose there, you've got definitions, and here it's a little different to the Tasmanian take. It's physical force to prevent, restrict or subdue movement of a student's body or part of their body. It looks at when physical restraint or seclusion may be used. And again, you note that this notion of immediacy, immediately required, minimum force needed, minimum duration required, and so on. And then there's a section about when it shouldn't be used, and then mechanical restraint, which I find interesting. Mechanical restraint should never be used in schools to restrict a student's freedom of movement unless the restraint is for a therapeutic purpose, with written evidence of the prescription recommendation or if required to travel safely in a vehicle. Well, we understand that. But the therapeutic purpose, I think, is interesting in that the research we've done with mental health practitioners suggests that there's a great deal of consensus that mechanical restraint is not therapeutic. So it would be interesting to tease out what's actually meant by therapeutic purpose here. So this policy is saying physical restraint, yes, may be permitted in certain circumstances, as is seclusion. And then it's very useful information about how to restrain, because we know in healthcare settings that deaths have occurred. So important point is try not to restrain someone by using a prone restraint, by throwing them to the ground and putting a knee on their back, or when they're facing upwards, just leaning across their torso, because that causes all sorts of injuries, and there have been coronial inquiries into people dying in hospitals as a result of prone restraint. So very useful guidance here. Now, in terms of other guidance, again from the Department of Education, there are guidelines that have been developed with the input of Dr. Shirley Pode from the Graduate School of Education. And this is quite comprehensive. And I should also note that in Victoria, we have the role of the principal practice leader, who's Mandy Donnelly, who is here tonight. And this is, I think, a very important step in the right direction, having this position, so that there is some checks and balances and education of teachers as to what can be done and what can't be done. And in relation to this particular guidance, you'll see here there's a lot of information about prevention, de-escalation, incident intervention, and response and recovery. So I highly recommend that you have a look at this site. There's a lot to it. There's lots of other links within it. So, for example, these take you to other links. And there you go, legal obligations. So very important resource. Please use it. All right, let's move on now. I want to talk in particular about children with disabilities, because it does seem that they are the ones who have been restrained more often than those without disabilities for whatever reason. And the little case law that there is on this topic does relate to children with disabilities. There have been numerous inquiries recently about children with disabilities being restrained. You might have heard about a box that was used at one disability service provider, which was called a desensitisation box, and there was an inquiry into that, which I understand is still ongoing. There's been the case up in Canberra of a child being put behind bars within the school classroom, and that also led to an inquiry. And the Victorian Equal Opportunity and Human Rights Commission in 2012 conducted an inquiry about the experiences of students with disabilities in Victorian schools. And it found that restrictive interventions weren't complained about that much, but 123 parents did refer to their child being secluded, put into a room that the child could not exit freely. There were, I think, around 50 incidents of restraint, but physical restraint. So it does occur, but what was interesting about this report is that the Commission noted there is no data collection, so we don't really know how often these interventions are occurring in schools. Whereas certainly in the mental health field, most jurisdictions now have reporting requirements, especially of mechanical restraint, but also in Victoria of any instance of physical restraint and seclusion must be recorded. So that, I think, is an important finding, that we need much more monitoring, but some sort of data collection so that we know when and where this is occurring. The cases that have come before the courts in relation to children with disabilities have attempted to find some recourse under discrimination or anti-discrimination laws. And I'll take you through three of those. But there are laws at a Commonwealth, a federal level, as well as state level. So the Disability Discrimination Act prohibits discrimination on the grounds of disability and other attributes. The Disability Standards for Education talk about making reasonable accommodation for children with disabilities. And then here in Victoria, we have the Equal Opportunity Act, which also talks about reasonable accommodation and prohibits discrimination on the grounds of disability, age, and other attributes. We also have here the Charter of Rights and Responsibilities in Victoria, but the limitation of this particular charter is that you can't sue under it as an individual. So other human rights legislation, you can sue, you can take an action to court saying my human rights have been breached, but you can't really do that under the Charter. It's limited in its powers. So let me take you through three different cases that tried to find recourse under these laws. And the first case I'm going to talk about is Kiefel's case, a very prominent name today. No relation, apparently, the young boy, James Kiefel, not Susan Kiefel, but James Kiefel was born in 1999, and between the ages of 5 to 11, he went to 3 different schools. He was diagnosed as having some form of autism spectrum disorder and language difficulties, both in understanding and in speaking, in communicating. And if he became distressed, he would often strike out. He would sometimes try to bite people and flail around. And so he had been restrained in each of these schools, and his mother brought a claim on the basis that he had been discriminated against because of his disabilities, that those without these disabilities would not be restrained in such a way. There was also a number of claims that he had been discriminated against because he wasn't given a full-time aide and he didn't have a proper behaviour support package and so on. And it was really interesting the way the judge in the federal court dealt with this, because he said, he made some comments that it's very difficult to prove discrimination under the Commonwealth Act in these sorts of circumstances. So the onus is on the claimant to prove beyond reasonable doubt, on the balance of probabilities, take that back, on the balance of probabilities. You can see I'm a criminal lawyer, I'm always talking about reasonable doubt. On the balance of probabilities that there has been discrimination. The trouble was in bringing these claims about James suffering injuries when he'd been restrained was that there were no eyewitnesses. So when the teachers were asked about what had happened, they said, well, we can't recall the precise incident. It may have happened, but if it did, it was necessary because he was striking out and he was hitting and he was clearly in distress. We had to do something. There was also an incident at the last school he went to where he was apparently, and this was admitted, put into a bathroom for 40 minutes and the teacher blocked the door. And she said that he had been very distressed, I suppose, but in such a state that she had to put him somewhere out of the classroom. And this was adjoining the classroom. She took him there, she stood at the door and waited for 40 minutes until he calmed down. And so his mother claimed that that was seclusion, that he was unable to leave that space. What happened was that the judge decided that redress was not available under this particular piece of legislation. And he said, if I can find it, I will just quote, this unfortunately is yet another case in which well-meaning parents have wrongly been led to believe that redress is available under the Disability and Discrimination Act for what they perceive to be deficiencies in the manner in which educational services have been provided to their children by the state of Victoria. So, as was pointed out throughout the course of this case, this wasn't the vehicle really for this claim. And I think that has sent a message to a number of parents that you just can't use this particular set of laws to try to find some sort of recourse for children with disabilities. The other thing that the judge said was that in terms of what the teachers said, look, he might have suffered injuries because we had to restrain him. The judge said, I have no hesitation in accepting the evidence of these teachers and aides. Any physical contact they had with James was justified and proportionate to the occasion. Such contact often occurred as an instinctive reaction in order to protect James from falling or causing harm to others. It did not occur with the intention of inflicting physical harm on him. On the contrary, the physical contact was often necessary to avoid harm. It must also be emphasised that physical contact of this kind did not occur because of James' disabilities. Therefore, case dismissed. The next case I want to refer to is RW. RW were the initials of the mother who brought a claim about her son, HL, that he had been restrained. Again, HL, the son, had been diagnosed with some form of autism, and he had been restrained on a number of occasions. The claim itself, though, was for indirect discrimination, and there's a little bit of a problem with that, because if direct discrimination is difficult to prove, then indirect discrimination is even harder. So this occurs where a requirement, condition or practice is the same for everyone, but it places a particular person at a disadvantage. To be unlawful, such a requirement, condition or practice must be unreasonable. So there was a claim here that HL could not meaningfully participate in his education without a full-time dedicated aide, without a formal communication method, and without a positive behaviour management plan. And then attached to that, there was a claim that he'd been the subject of physical force, restraint, isolation and seclusion in breach of the Victorian Charter of Rights and Responsibilities. And again, this came before the tribunal, the Civil and Administrative Tribunal, and the finding was physical restraint did not fall within discrimination laws. And further, there was no power to consider charter claims. So this shows that the courts are saying, look, we have sympathy for these actions, but this isn't the right set of laws to find recourse. The only positive aspect about this is Scandalera's case, where there was a claim made in relation to twin boys, again on the basis that they had been restrained in a school. And what happened here was that it was settled in mediation. So there is a line of thought that you still can bring these claims, because it might be that the state will settle before it actually gets to court. But you can see from these cases it's very difficult to get damages, let alone any recourse under anti-discrimination laws. All right, so let's get to the final summary, if you like. Where are we now? I've been looking in particular at, I suppose, the higher end of behaviours of concern. There's some work being done in South Australia by Anna Sullivan and her colleagues, and they gave a survey to something like 1,300 teachers, and it seems that the teachers were probably more concerned about disengagement and low-level disruption than these sorts of behaviours. So it may be that the case law is really about the high-end behaviours of concern. Nevertheless, in that survey, 53% of those who answered said they felt stressed by their students' behaviour. I thought that was actually quite low, but there you go, 53% were not impressed by their students' behaviour. I think there's really a desperate need for a national approach. I know it's very difficult in the law to get consensus on a national basis, but it's so piecemeal at the moment that it would be great to even just have a model law or model guidelines in this area. I think the real gap here is that there's no reporting requirements. We've found in relation to the mental health sector, reporting works. That once people had to report seclusion rates started falling. And it really gives you an idea of where and when seclusion might be occurring. So you can then think about, can we change the culture of this particular place? Children with disabilities do appear to be most affected, but as I've indicated, have limited redress if they have been restrained. And again, it comes back to the courts thinking in terms of reasonableness and necessity. There's a lot out there in relation to preventing this end of behaviours, of having to use restrictive interventions. And I wanted to just point you to this Promoting Positive Behaviour site, again from the Department of Education. Really useful resource. And it talks a lot about planning, again, prevention being better than the cure. And there's a lot of resources out there about how you really nurture positive behaviour. The South Australian researchers, Anna Sullivan, that I mentioned just before, they have a website which is called BAS, Behaviour at School Study. And again, there's a lot of resources on that website about how do you write behaviour plans, how do you work with parents and so on in relation to those who are displaying behaviours of concern. So I'm not an expert on this. I know Professor Keith McVilly here at the university has worked a lot with students with disabilities and the Office of the Senior Practitioner in coming up with positive behavioural alternatives, different options to promote good behaviour. So you could always Google his name, Keith McVilly, and have a look at some of the guidelines from the Office of the Senior Practitioner in Victoria. All right, so that is a very quick whirlwind tour of what's happening here in Victoria. And I think the end result of all this, what I want to really stress, is that prevention is better than the cure. If you're in a situation where you have to use physical force, make sure it's reasonable and necessary, and just try to grasp the person's arms. Don't wrestle them to the ground, because that can cause all sorts of difficulties. And most of all, I suppose, in conclusion, in relation to this theme of prevention is better than cure, I just want to read to you one of my favourite writers, nice quotation, since we're in a building full of quotations, from the writer Anatole France, who said, 9/10 of education is encouragement. Thank you very much.